Hello, I'm Diane Birnholz. Now, is RYAN WESLEY ROUTH'S right to represent himself in the attempted Trump assassination case absolute? No, it's not. A defendant's self-representation has limits in that it will not be allowed to interrupt or delay the proceedings or to make a mockery of the trial. And that makes sense. A defendant does not have the right to engage in misconduct, which could be any number of things during a trial, like repeatedly interrupting the judge, or mentioning evidence that's been ruled inadmissible, or making repeated invalid objections, or constantly meandering off topic. I mean, things like that. So here, Ruth's behavior in the Trump attempted assassination case has already impacted the trial, even in the earliest stages. The judge admonished Ruth multiple times during his opening statement because Ruth is bringing up all kinds of irrelevant topics, like various dictators from around the world, past and present, and asking what happened to the species Homo erectus. The case against Ruth is actually progressing quickly because Ruth isn't doing much in the way of cross-examining the government's witnesses. A defense attorney would likely do much more. And when I was a federal prosecutor, I had a similar experience with a defendant who was assigned an attorney with the Federal Public Defender's Office, but he then petitioned the court to represent himself, which was granted, which is just like this case. And the defendant in my case, though, was accused in a string of bank robberies around Los Angeles. And because of his self-representation, a number of interesting issues came up that I had never dealt with before. And first, in the initial stages of a case, the prosecutor turns over discovery, which is copies of the evidence and usually a proposed plea agreement to the defense. That's pretty standard practice. And here I was sending these materials off to the defendant himself at the Metropolitan Detention Center, and he would write me back, and security officers would open up and examine his letters before they got to me, since they were coming from a defendant in prison. And we also needed to discuss the case by phone, just like I would with a defense attorney. But for obvious reasons, I couldn't be talking to a criminal defendant, even when representing himself, without a witness present to the conversation, because I didn't want to be accused of saying anything improper or making any kind of promises. So the logistics of that were complicated. So what I arranged with my bank robbery defendant was that he would call me, collect from the prison, and I would get that tape recorded message, "Will you accept a collect call from MDC?" And I would get that call once a week at a specific time that we had agreed on. And I made sure that my FBI agent was always present, and then I would talk to the defendant on speakerphone about our case. And he handled himself quite professionally, and more so than the defendant in the Trump attempted assassination case. Stay tuned for my next video, and thank you very much.